But that won't happen, and there's a good reason for that. There's a reasonable way forward for these types of cases to go quite far. Perhaps all the way to the Supreme Court. Even if these attempts are probably unsuccessful, it is not unreasonable for citizens to resort to this path. It might even work. Groups such as Citizens for Responsibility and Ethics and Free Speech for People in Washington are planning perhaps the most notable efforts to use 14th Amendment in this context. They plan to sue on behalf of residents of various states and will even question Trump's right to stand in the GOP primaries next year. Conservative professors William Baude and Michael Stokes Paulsen, who backed this case, examined the historical evidence and concluded that the relevant constitutional language clearly applies to Trump's behavior on January 6, 2021. While some scholars oppose this, others support this claim. So what are the benefits of legal challenges in this direction? They'll probably go pretty far. State legislatures have already established processes this purpose. And while they can be used for frivolous ends, they also allow serious action. Election law expert Justin Levitt of Loyola Marymount University School of Law told me many states provide a mechanism for questioning candidates' qualifications before they are put on the ballot. But rules about who can file these challenges and when does vary. Under state law, when a candidate appear on the ballot, any person eligible vote in that contest has 7 days challenge that candidate's constitutional qualifications in state court, according a new Crew analysis of the laws governing such challenges. Follow Greg Sargent's opinions, and this court's decision will likely be challenged in the U.S. Supreme Court. In 2016, a voter challenged Senator Ted Cruz' candidacy Pennsylvania, arguing that he was born in Canada, but the provincial Supreme Court ruled Cruz' favor. In another example, eligible voters in Illinois and New Jersey may attempt to take action through an administrative agency process to prove that a candidate has been disqualified. According Cruz' analysis, this agency's decision is subject to appeal in state court and will likely go to the state Supreme Court and possibly the U.S. Supreme Court. Crew and FSFP did not disclose which states they plan to target with the lawsuits. But a source familiar with the planning work said they will be available this fall. Here's the trick: this only needs work in one state to go the Supreme Court. Yes, many state Supreme Courts will uphold Trump's eligibility. Loyola Marymount expert Levitt expects states to generally decide whether Trump has the power to determine qualifying status under the 14th Amendment. This is where things get complicated. State courts usually decide whether candidates are qualified. However, Levitt makes a distinction between direct factual requirements and the requirements that require interpretation.